Um,
Go ahead, Tammy. And this is just so people know at the start of the video, this is Transition Talks Tuesdays with Madison Metropolitan School District. And we're with Tami Jackson from the Wisconsin Board for People with Developmental Disabilities, talking about supported decision-making and guardianship. Thank you so much for being here, Tammy.
well, I'm glad I could make it, literally. Um, so as I was saying, you are in the thick of it right now. You have a young person who is getting older and they are soon to be an adult, not unlike young people without disabilities who are in the same process of becoming adults. Um, and for a lot of parents of people with intellectual and developmental disabilities or kids with other kinds of disabilities, this is a really challenging time. And what we're going to talk about are some of the challenges and fears that are common across. We've talked to literally hundreds of families across the state, many more over the years. And you guys all share some common fears that we'll talk about today. And we're going to talk about some of your options as your child ages into becoming an adult, including supported decision making. Let's advance to slide 3. So, first of all, under the law, Wisconsin presumes all adults are competent to make decisions. And adult under Wisconsin law means somebody who has attained the age of 18. It's a kind of arbitrary number. There's not really a big difference between somebody who's 17 and 364 days and somebody who is 18 and 1 day. But the law says, well, this is the bright white line. And if you're over 18, you are an adult. I don't know if you or I would not make the same decisions I made at 18 that I do today. And I don't know if there's any decisions you made as a much younger person that you would not do today. But I can say that decision making is a learned skill and that you need practice doing it. And there's some people at age 18 who are really, really good at making all sorts of decisions. And there are some people at 18, including some of us without disabilities, who might have needed to learn through experience and practice. And there are some people who are much older than 18 who have never run into a decision before and all of a sudden have to make a decision about a topic that they don't know about. And the point is that, we learn decision making over time and that you get better at it when you have experience. And the other piece is that all of us, 18, 20, 40, 60, we all use some sort of support in making our own well-informed decisions. And that is, we all have a group of people who we turn to get advice, to help weigh options, to talk something through with before we make our own decision. And your kids have already had a lot of practice in various kinds of decision making. We don't often think of it as practice for decision making, but it is. Simple choices: what to wear, what do you want to eat, are there preferences that people have, allowing no to be an option. How do you want to spend your time, or who do you want to spend it with? Has your child, increased their decision making over time? I think if you think about it, the answer is probably yes. That the young person that entered kindergarten is in a much different position making, with their decision making abilities now than they were back then. And that it's, we all grow over time. Next slide, please. So Wisconsin's law says that if you're over age 18, that artificial line, you are capable of making your own decisions. But there's something else in play here, and I bring it up because people with disabilities are assumed in some ways to be not competent to make their own decisions. And there's actually a term for that. the law says you're competent if you're over 18, but if you have a disability, culturally, we assume that that makes you less able to make decisions because of the presence of a disability. That isn't true, but it is a bias that you will see in lots of places in your life. And perhaps you've already experienced it as a parent or as a young person with a disability. I work with a lot of people with disabilities, and many of them will describe being in situations where I always pick on healthcare professionals because they typically don't attend my presentations, so they don't get as angry with me. But it's also very relatable because lots of people go to a doctor and have had some version of this experience. A lot of people with disabilities will describe that they'll enter a room, perhaps with somebody, could be a friend, could be a parent, could be, a caregiver, and the professional will see the disability and start talking to the person who is with them and not to them. Or say into the room, oh, who's the guardian? Because they're looking for somebody else to be the decider. A lot of times professionals may see, all sorts of arrangements as being the same, like powers of attorney and guardianship, where they're very different. And sometimes we have, built in our assumptions into the actual forms that people fill out, where there's an assumption, say at a bank, that somebody is either a power of attorney or a guardian, and there's no space for a supported decision-making agreement, for example. And you may have experienced this yourself. If somebody's looked to you to be the final decider, for example, or if you have been in a meeting where the person with a disability really isn't involved in the decision making, it's a conversation between family members and the professional. You may also have experienced that the whatever system you're interacting with is wanting to drive decision making based on its needs or requirements, not the person with the disabilities wants or desires. So that might look like, well, we need you to, it would be easier if you were a guardian because we know how to interact with you. And that's easier for us, for example. And all of that is something we don't necessarily think about, but is around us all the time. And people with disabilities really do feel and learn from those interactions. And they're learning all the time from that. And unfortunately, the things that they are learning on the bottom of this slide here aren't particularly positive. When you learn that somebody is that you are not involved in decisions about your own life, you don't get necessarily the practice with decision making. You're learning that others speak or decide for you, that your preferences don't matter, that you don't have control, that you can't say no, that you must comply. And coincidentally, a lot of these lessons are really detrimental, not only to somebody's independence and ability to articulate what's important to them, but also as real signs that somebody could be more easily victimized or abused. Next slide. So self-determination is a longer, fancy word for saying, do I get to make decisions about my own life? And people who do make decisions about their own life, evidence shows, there are studies on this, that they are healthier, more independent, more well-adjusted, and better to recognize and resist abuse, or safer. All of this makes sense because we all feel better about being able to be in control of the choices we have to make and the decisions that we make, even if those decisions end up to not turn out the way we thought. You're always much happier having been able to decide it yourself than having something applied to you and being also dissatisfied with the results. Next slide. So I said you were in the thick of it. And when I present to other professionals, I remind them that, you know, families who are transitioning a child with a disability into adulthood are doing a lot of different things. They're all high stakes decisions. Lots of them require extra paperwork that has to be completed in detail and correctly. And they kind of are all happening at the same time. So for lots of folks, they're trying to figure out Social Security. They may be thinking about, how do I transition from the children's long-term care program to family care or IRIS, and which program should I choose? They may still be into school or choosing whether to stay in school until 21. You're transitioning from, I need a new set of doctors, and it's scary to have to think through who will be taking care of my son or daughter's medical needs when you've had perhaps existing relationships for a long time, maybe even since birth. All of a sudden you're doing DVR. You know, are you needing to think about housing vouchers, or is your person going to live, you know, with their family or into a group home or into independent living? These are all really big transitions, and some of them are the same kind of transitions that children without disabilities go through, right? Like, but some of them are kind of extra special in terms of, you know, all of the different systems that parents are expected to kind of be navigating at the same time. And then thrown in on top of all of this is, who, you know, and often it's phrased this way, who's going to be making decisions for your person? And that's kind of a misleading statement, because we wouldn't ask that if the child was without a disability. We would just be assuming that at 18, that person would be an adult. But again, that cultural bias assumes that a person, by having a disability, is less competent. And so oftentimes in the thick of families trying to figure all of these things out, they're asked what they see as a very benign question that's actually really consequential for their future and the first future of their person. Next slide. So there are lots of different strategies and tools for people who might need help with decision making, and not all of them are particularly invasive. Most of the time, people with intellectual and developmental disabilities are really only familiar with or talked to about the purple column, which is limited or full guardianship, and largely it's full guardianship. That is the most restrictive thing that you can do to anyone. And it's often the only option that families are familiar with. And it's the one that they are talked to about first. But there's lots of other tools that are at your disposal that are not guardianship that may be an appropriate choice as you think about transitioning into adulthood. We're going to start with the least restrictive. And when I say least limiting and more limiting, there's that little arrow on the bottom of the screen there. What we're talking about limiting is somebody's civil rights. There are plenty of supports for people with disabilities that do not impact their legal rights to make their own decisions. Guardianship does. Guardianship is actually going to court, and the purpose of that court hearing is to have the court adjudicate and say, you are not competent to make your own decisions. We are removing some or all of your civil rights to make your own decisions, and we are transferring those rights to another person, the guardian. So that's what we mean by less and more limiting. We're talking about civil rights. And like I said, guardianship is the most restrictive thing that you can do, because it does in fact mean that a person, the guardian, is assuming responsibility for a good part or most of the decisions that really do determine what somebody's life may look like. So starting on the green column, release forms, very common, use them a lot. Nobody's losing civil rights when you sign a release form. You are giving permission for another person to access information. And this can be a useful tool for family members. It's an acknowledgement that you have a role, and the person is giving you permission to see information. We don't even think about these when we're signing them, but the purpose that they're serving is really a liability protection. They're telling the professional you're interacting with that it's okay for you to have this information, and that person is making the decision to allow you to see it. And some release forms can be in place until they're changed. They could be put in place forever. Some of them, they may want you to sign every time. Those are fine. That's okay. You need the release form, not necessarily a guardianship, to access information sometimes. Supported decision-making agreements, and I have in parentheses Wisconsin, are another tool. They've been in place since 2018 in this state. I have parentheses Wisconsin because not every state has a supported decision-making agreement law. I think we're up to almost 20 now. But that's 20 is not 50, and there's 50 states. In our state, the beauty of supported decision making is the person who needs the support chooses who they want to help them, and what kind of help do they need, and how do they want that person to help. And that person has the supporter has specific roles that they can do that are helpful to the individual, but the individual is always the decider. So the individual doesn't lose their civil rights to make their own decisions, but there is a codified role for a person or other people to serve as a supporter to kind of help them think through all of the different ramifications of making those decisions. For representative payee, for those who are receiving Social Security benefits, this is a person that Social Security can designate to receive the monthly benefit checks. And that payee does have control over how that funding is spent. Again, the person doesn't lose their civil rights to make their own decisions. They do lose a direct role in managing that benefit check, but it is a tool that a lot of families can use if you are worried about a benefit check coming in and not being spent on rent or other kind of basic needs. I need to update this slide because there's also something in Wisconsin law called conservatorship, where the individual themselves volunteers and goes to court, and the court then appoints a person that the individual wants to help manage their finances. That can be changed at a later date by the person. So it is voluntary and driven by the person. And that is a stronger role for someone beyond just managing SSI benefit checks, to manage more finances. Of course, that's based on the permission of the person. So they're not losing their civil rights to make financial decisions, but they are saying, I need help with this. And the court is saying, okay, here's the role for the conservator. In the red column, we have powers of attorney. Again, lots of people use these. I have attorney friends who says everybody should have one, and they give 57 reasons why. Powers of attorney can be written in several ways. They're good for two big categories of decision making in the state: power of attorney for healthcare and power of attorney for finances. And they can be written in a number of ways. They can be written so that they are always active. That's called durable power of attorney. That's more common with financial powers of attorney. And it basically gives another individual co-equal decision-making authority all the time. There's a reason that that's a little bit rare. Like, you better really trust who you give a durable power of attorney to for your finances, because it means that person can make decisions about how to spend your money equally as you. More commonly, powers of attorney are written so that they are triggered when an individual has met a threshold of incapacity. So for example, if I had a medical power of attorney, and let's say Tim is my medical power of attorney, if I end up in an accident where I'm in a coma, very clearly I can't make my own decisions if I'm in a coma. So my power of attorney is triggered, and then Tim is transferred my decision making authority over my medical decisions. And when I wake up out of my coma, I regain my capacity, and Tim, still my power of attorney, is no longer the decider, because I'm able to do that for myself. So it kind of can switch on and off based on your capacity. And then finally, the most restrictive thing that can happen, you do lose some or all of your civil rights, and that's limited or full guardianship. We kind of covered this already, that's the place where you are going to, you, the petitioner, the person, generally the person who is petitioning to become the guardian, is saying to the court, I want you to rule that this person is legally incompetent to make their own decisions, and appoint somebody else to do that function for them. And then the guardian is the person who has becomes the person who makes decisions. Next slide, please. So guardianship, there are two kinds of guardians. There's under state law, there's the guardian of the estate and the guardian of the person. Oftentimes, the same individual will be appointed both roles, both guardian of the state or guardian of the person. That does not need to be the case. That's not always the case. There are some times where there might be a guardian of the estate, but not the guardian of the person. There are times where there might be a guardian of a person, not guardian of the state. That's rare. And there are times when there may be an individual appointed guardian of the estate and a different person appointed guardian of the person. All of those are possibilities. They have separate and distinct duties for each role and separate powers under the statute. And there are administrative requirements that are required of each. And that can vary based on where you live. So that's one thing that a lot of people who are thinking about becoming guardians aren't necessarily aware of on the front end. There's actual real, paperwork and reporting responsibilities. And in some areas of the state, there may be some requirements that do require you to get a judge to sign off, say, on a certain amount of spending. That's fairly common. So it behooves you to kind of understand what those administrative tasks are on the front end. Next slide. A lot of people have only heard about guardianship, and I've just listed some of the things that we have heard over the years that are all not true, but are very common things that we've heard. Maybe some of you have heard these same type of myths. Um, for example, we hear from a lot of parents that they are told that, well, if your kid is over 18, then you can't attend an IEP meeting unless you're the guardian. That's actually false. All that needs to happen is that the student needs to give you permission to be in the meeting, which might look like, Johnny, can I still attend your IEP meeting? Yep. Okay. That's, you don't need to be a guardian to attend the meeting. You just need the permission of the student to do that. And a lot of times, there's not a ton of support for people who become guardians. So it really, people really aren't aware necessarily of, you don't make all the decisions. You don't get to say, hey, you can't wear red ever again if you're the guardian. That's not the purpose of the statute. But what happens is that, people tend to tend to perhaps have a little bit of creep in what they think that they are allowed to decide. I think the biggest piece that is a real challenge for folks is, when you're going to court and you're asking a judge to say this person is legally incompetent, that is a really big deal. Sometimes folks think that they can change the terms or tell the court how they want the guardian set up, or pick who the next guardian is. Once there's a guardianship in place, the court is always the final decider. And there have certainly been parents who have thought that they gone to court thinking that they could tell the court, hey, here's the rights that I want my child to have. And the court said, nope, we don't do it that way in this county. All the rights are taken. We've certainly seen parents who have said, hey, I'd like to change the terms of the guardianship because, hey, this person has grown. They can make their own decisions in this area. They're very difficult to change. And part of that is because what you're asking the court to do is assess that somebody's ability to make decisions. And if they assess that the person does not have the ability to make decisions, when you go back to the court, their question is, well, what's changed? Did we make a mistake the first time, or have you increased your capacity? Have you you almost have to prove that you have gained decision-making ability. Oftentimes, especially with young adults with IDD, if you get a guardianship at 17 and a half or 18, before the brain doesn't mature until about 25, the guardianship is being decided in that moment in time, and it's people don't go back because it's expensive to go back to the courts, and the court is always thinking about, did we get something wrong? What's changed? And it's hard for people to affirmatively prove that they always had decision-making ability when it was taken away at a young age. The other piece that's really important for parents is that, there's things that you can control and things that you can't. None of us can control the future. So we may have the best laid plans or assume that, well, if something happens to me, my spouse will take over, or one of my children, or some other person. And the court is always the decider, first of all. They will choose who the next guardian is. They do defer to family members' preferences often. You can name a successor guardian. But a lot of times, life intervenes, and perhaps the plan as it existed when the person was age 20 may not be the same at 25 or 30 or 40 or 50 or 60. There's a lot of parents who are guardians and facing down their 70s and 80s and going, what I thought was going to be the plan for this person has changed because perhaps my children died, or maybe they're 5 states away, or my spouse was going to take over, but they are no longer into the picture. Lots of things happen that you can't predict. And a guardianship is oftentimes a lifetime commitment. Next slide. I'm going to go through this fairly quickly because you will get these slides. I think the main takeaway that for families to think through is that when you are a guardian, you get to be responsible for a lot of things, and it's a really heavy role. It's not only administrative requirements. Some of the decisions a guardian may be charged with making are literally life and death. They are medical treatment decisions. They're where somebody lives. They are, making sure that that person is still on Medicaid. And there's very few other people who are willing to take on that entire role. So, in the instance, and there's oftentimes cases where there perhaps isn't a successor guardian. And then the person, the court will appoint another guardian, and it will likely be a corporate guardian. And a lot of times the person may not know know their corporate guardian. The corporate guardian may be a guardian for many different people. And, their lives are in somebody else's hands with court oversight. So it's important to think through, like, what you're willing to do now, will somebody else be willing to do it in the future? And will your ability or willingness to be a guardian change over time? Because none of us can predict exactly how we age either. And there's certainly a lot of decision. Somebody who's a guardian at 40 may be in a different place at age 60. Next slide. We'll skip this. Next slide. The main point, I think, of all of this is, when you think back to that slide that shows you many different tools, the only tool that really can't be used with anything else is full guardianship. And that is the most restrictive option, and it doesn't need to be considered first. Many families use a combination of things. They might use release forms and powers of attorney and supported decision-making agreements all at the same time. That's perfectly fine, because none of those options are affecting the individual's civil rights or their legal rights to make their own decisions. Even if you have a limited guardianship, which is, the person retains some of their legal rights to make their own decisions, but others are transferred to the guardian. In those areas where they've retained their rights to make their own decisions, you can use powers of attorney or supported decision-making agreements. The only thing that isn't flexible is full guardianship. But there are many, many other tools that families have that they can take advantage of and try out. You can always petition for guardianship later. There's no magic age at which you can't petition for guardianship or it's easier to do so. Whether or not somebody is appointed a guardian is really supposed to be based on their capacity to make decisions. So if you try out some of these tools at 18 and at 25, it's not working so well, now you have that data, and yeah, you may pursue a guardianship. Maybe that is the right decision. And maybe it is the right option at an earlier age. But we really want families to understand that they don't have to start there, and that if they need to go to guardianship, it's always there as an option. Next slide. There will be some training for prospective guardians that will, we hope, help explain what their role is under the law. Being a guardian doesn't mean you get to make all the decisions. In fact, as a guardian, you're supposed to place the least possible restriction and promote the greatest integration, and do your best to identify and honor the individual's preferences. We copy this straight out of the statute because it is something that sometimes is not always, the spirit of the law is not actually always in practice. And it's really important for people to understand, if they are going into a guardianship, that this is what you are supposed to be doing to actualize the spirit of the law. Next slide. So now we're supported decision making. Okay, we're going to do this. Next slide. Supported decision making is really based on 3 principles. People can make choices. They can have help without giving up their civil rights to make choices. And we often need help in making choices. Supported decision making is something that you and I, as individuals without disabilities, use all the time. Every time we ask our group of friends, hey, who do you know that would be a good, it's tax season, let's use taxes as an example, a good person to ask about tax preparers. And you have 3 or 4 people who say, here's my experience with this person or this person or this person. You may get a referral, and then you kind of consider the information and make a decision. That's frankly supported decision making. All of us use it all the time. Why do we need a law? Well, because again, ableism presumes there are certain people who are less able to make decisions, even though they're doing the exact same thing that you or I do when we're faced with a decision that perhaps we have less experience in making, or that we just want some extra opinions on. Next slide. So in Wisconsin, we all use supported decision making to get through life, but only certain people in Wisconsin can use the formal supported decision-making agreements. And that includes people with IDD and mental health illnesses, as well as people with physical disabilities who have limitations on daily activities or degenerative diseases, people of any age that meet the criteria of functional impairment. No, you don't have to go and get a doctor's note to assess whether you have a functional impairment. Wisconsin's law presumes that if you say you have one, we believe you. If you say that you need a little help to make decisions, that we will agree and honor your assessment. Next. So the supported decision-making agreements, here's what they don't do. The person is always the decider. You'll hear me say that a lot. The person who is making the agreement is always the ultimate decider. The supporter doesn't gain any new rights. The supporter doesn't have authority to make the person's decisions. The person makes their decisions. They can't sign somebody up for something or commit them to a legal contract, but they do have some roles that can be important. Next slide. And the roles that a supporter can play are these 4 things. They can help somebody get information relevant to the decision they have to make. Oftentimes, just researching and figuring out and getting information is a huge barrier for people. Think about the last time your elderly parent, I'm projecting, this is my experience in the last 2 weeks, your elderly parent asks about a technical support issue or what kind of computer they should buy or that type of thing. There's a lot of information out there, and there's a huge role for helping somebody sift through and figuring out what's relevant to the decision they're making. A supporter could help somebody understand that information. Anytime I read a letter that is drafted by an attorney or somebody at a state agency, I usually read it at least 3 times, because sometimes we don't make it easy to understand what somebody has to do. That's a huge role, especially for folks who, may have some sensory limitations, or are starting, or have some cognition, or just lower reading skills. You can help that person understand their options. In other words, what any friend or family member might do, which is kind of help people compare what their options are. Option A, here's the pros and cons. Option B, here's the pros and cons. And then the person thinks about it and says, I'll go with option A. And the fourth one is assisting with communicating the person's decisions to others. I actually underestimated the power of this when we first passed this law. Because for a lot of people, and I'm thinking of some of our friends with cerebral palsy, this fourth thing is the only thing they want from their supporter. They want somebody to help be a translator for them to another person who isn't familiar with their particular communication style. Sometimes people are nonverbal, doesn't mean they're not communicative, but it may mean that the person they're interacting with doesn't know enough about them to be able to interpret what it is they mean, or a speech impediment or other things. For a lot of people, this fourth role is really, really been what they want. Next slide. So I have this in here because even when you're helping somebody get information, that doesn't mean any information. And no, you can't just disclose it on Facebook or other places. A supporter is supposed to make sure that personal information they access is kept privileged and confidential. And you may have to sign a release form to get information too. There's nothing, nothing wrong with that. So if I'm helping figure out who's a good tax preparer, that doesn't mean I get your health records, is really what we're trying to say here. It's only the information that's relevant to the decision the person has chosen for you to help with. Next slide. Yes, you can have multiple decision-making agreements. That's deliberate. All of us have people in our lives who we know have more expertise in one area or another. I wouldn't ask the same person in my life about advice for buying a car as I would, where to buy flowers. That's a rather silly example. But the point is that people have different folks in their lives that have their own expertise. And the supported decision-making agreements are designed to be flexible so that you can maximize the expertise of all the people that you know. If you're a guardian, you get to be responsible for it all. And actually, the family members that helped pass this law, they would often say that was the biggest benefit to them, is they could think of a whole bunch of people connected to their person's life who might be willing to take on a small role or a small way of supporting them in decision making, but they couldn't think of one person who was willing to take it all on and become a guardian. So, it's a way of kind of broadening your network, and if you have holes in expertise, then you know that, and you can find, you may be able to find somebody who can fill that for you. Next slide. Supported decision-making agreements are totally governed by the individual who is making them. So they're always in control of their own decisions, and they're always in control of their supported decision-making agreement. And there's a number of ways that you can design agreements. You can decide when it ends. You can say, nope, I don't need help with this anymore. A supporter's life might change, and they may say, hey, I can't provide the same level of support. We have a whole toolkit, and really supported decision-making agreements, you should revisit them. And you should say, is this working for both of us? Do we need more or less here? Do we need another person who's able to take on part of it. It should be a conversation, and it's part of the flexibility of the agreements is that you can have these conversations and evolve these agreements, either less restrictive or more, or needing more help over time. It kind of breathes with the person and their experience, and if they're gaining experience and feeling more confident, the agreement can reflect that. Next slide, please. Just a couple other features that were passed in the law, and the only one I'll really highlight here is, now that there are a number of alternatives to guardianship, the courts are now supposed to ask, hey, have you tried any of these alternatives, including supported decision making, and have, would those less restrictive methods of helping somebody with a decision work? And that's important to know. It's kind of a stop in the, a pause in the law, to kind of say, hey, you're about to proceed with a guardianship, but there are other tools. And this is one of them that can be that can be used for decision making. The other important feature is, professionals receiving the supported decision making agreements do have to recognize them. They are legal agreements, and they should be assured that they are a representation of the wishes of the person. So that really gives, the supporter some standing in terms of, like, I'm here, here's who I am, here's the role I serve, and the professional can look at the agreement and go, oh, okay, you're here to access information and nothing else. Or maybe you're doing a combination of the 4 roles we discussed. It gives the supporter a defined role and this that a professional can recognize. Next slide. All right, using these things. Next slide. So one of the great advantages, I keep talking about flexibility of these agreements. They really can be used for any decisions that a person needs help with. So they're much more flexible. A power of attorneys are great, but they're really only for healthcare decisions or financial decisions. And there are lots of decisions in life that aren't either of those two things. A lot of people, the decision, especially for older adults, the decision of, am I, where do I need to live in a different place, and what should that look like? That's a huge one. And you can use supported decision-making agreements for all sorts of things, large or small, that the person thinks are important. Again, they can be updated easily. Some people, I deal a lot with young people with IDD who are going to perhaps gain capacity to make decisions over time. The reverse can also happen. Somebody can be able to make their own decisions and have that capacity decline due to aging or an advancing condition. The agreements can shift as the needs change. Next slide. The form is actually in the statute, and it's on the DHS website, and there are some standard elements in it. What I'd highlight here is, the person who whose agreement it is the person who's deciding who's my supporter, what do I want help with, what do I want my supporter to help me do, when's the agreement good for, and all you need to make it legal is the signature of the supporters and either 2 witnesses who are over age 18, that legal age when you're an adult, or a notary public. You don't have to go to court. You don't need to have a lawyer set this up. This is designed to be easy for people to do and to change. So you could download the form, you could fill it out, 2 witnesses over 18 or a notary public and the signature of a supporter, and you have a valid agreement. Next slide, please. Excuse me. So there are some types of decisions that are itemized on the form. The really important part, the thing that makes these so flexible, is the last bullet, other decisions. Lots of people want help with the things that are on the form, but that space of being able to write down, here's what I specifically want help with, makes this document, makes supported decision-making agreements extraordinarily flexible. You can make them as narrow or broad as desired. And they can be on all sorts of topics that maybe aren't covered under other alternatives to guardianship. Next slide, please. The law also presumes that if you don't check yes, if you don't affirmatively say, yep, this is how I want you to help, the absence of a yes or no means that you don't want the supporter to help. So the supported decision-making agreements always err on the side of the person who's writing the agreement having the greatest authority to exercise their own decision-making. And if they don't say yes, they want help, that means they don't want a supporter to help. Next slide, please. Next slide, please. We've talked about flexibility of decision making. I think this is the biggest thing when we talk about older adults, especially. My advocate friend Janet would say, you know, sometimes the best thing about supported decision making agreements is it broadens the network of possible people who can serve and do something to help somebody. And she would always say, you know, I have a lot of folks who are older where perhaps they never had children, or they have children, but they're, you know, maybe not in the area, maybe they're in another state, who knows, that the people who are closest to them are actually friends. And those are the people who know their day-to-day routines, who are involved and engaged in their lives on a routine basis. It's not always family members, and there's some people who don't have families. And supported decision-making agreements can be used with anyone that the person chooses to be a supporter. We did that deliberately because there are an awful lot of people where perhaps the closest folks to them are neighbors, or, you know, third cousins, or, you know, friends, or people even that they have worked with, colleagues. And if the supporter is willing to help in a specific way, why should the person be able to choose whom they trust to help support them in their decision making? Next slide, please. We've kind of covered this. I think the main point that I want to say is there are an awful lot of people who need just a little bit of help for a long time. And, you know, if you're in your 60s, for example, and starting on the beginning edge of Alzheimer's, you may end up with a guardianship, but you may not need it until you're 80 or later. So why start at 60 with a guardianship when you can maintain your own autonomy, your own choice making for as long as possible, with a tool that allows you to transition to something stronger? And eventually there may become a point where, yes, guardianship, or, you know, or another stronger decision making support is the right tool. Next slide, please. Plenty of people are using supported decision-making agreements already. It's a relatively new law, passed in 2018. And you guys are the pioneers. You guys are folks who are taking these agreements to all sorts of meetings with state agencies and care plans and doctor's appointments and banks. I won't say it always goes perfectly, but it's been working pretty well. And there's lots of ways that folks are using these agreements without pursuing a guardianship. Next slide, please. We've kind of gone through how important it can be to have an SDM agreement. It does result sometimes in better communication, both from the person to the professional, to make sure that person is really heard and understood. Next slide, please. And sometimes the reverse is also true. If you're somebody who, you know, a second set of ears is oftentimes a good thing. And supporters who know the person fairly well can translate from the professional to the person too. Sometimes you may describe something in a way that makes sense to the person that the professional wouldn't know how to do, because they don't know your person the way you do. So there's a lot of examples that make this very useful. Next slide. We have a tool, and next slide. We have a toolkit that Tim typically sends out afterwards that's intended to be a helping workbook for families and people using supported decision-making agreements. And it includes this sheet of, remember, when you're interacting with me, the person with a disability, here's what I want you to know as a professional. I'm going to skip the next 2 slides, Tim. Sometimes when we're presenting to professionals, we include a couple other slides that are helpful in terms of engaging and interacting with people with disabilities, because there are professionals that have a variety, a degree of experience with that. The resources that we've included, next slide. The supported decision-making agreement form is on the Department of Health Services website at this link. You can download that form and look at it and fill it out at your leisure. The last slide here, next slide. Here is a link to the toolkit that our organization, as well as some of the other aging and disability advocates have put together. And it's intended to be a more plain language version to help you kind of think through, what makes sense for you and your family. And it may not be a supported decision-making agreement. It may be that you need a combination of things like powers of attorney and a conservatorship, or a rep payee, or a supported decision-making with all of those things. Or maybe you do just need a supported decision-making agreement, or maybe guardianship is the best choice. But we've kind of put together a resource here that helps you kind of work through some of those questions as a family. And then, of course, because I'm me, I have to include the actual link to the statute, just in case anybody recreationally wants to read the state statutes as I do. Okay, next slide is questions, and we are at question time. I apologize, I went through very quickly, but I'm also trying to be mindful of time because we got a bit of a late start with our technical difficulties. Tim, you are also going to be the only person who can see the questions, if there are any. So I will rely on you again.
No problem. So what I would like to do is I am going to take a moment, now that I don't have the slides in front of me. I'm going to put a couple of links in the chat for some feedback and some surveys. So please feel free to either unmute and we'll call on you, or also Sheena is able to see the questions. So Sheena, if you might want to just go through any of the questions that are in the chat. And I think for this point, I think I'm going to change my mind now, and I'm just going to turn off the recording right now. So thank you all for listening. And now we can move into questions. One moment.